Ever wonder how rock-solid forensic evidence truly is? Today, we're diving into a fascinating cross-examination, where a defense attorney meticulously chips away at a ballistics expert's testimony, questioning the very foundations of how bullet casings are matched to weapons. This isn't just about technical jargon. It's about casting reasonable doubt where prosecutors often claim certainty. Welcome back to the channel. We're breaking down a pivotal moment from a criminal trial, likely involving charges where firearm identification is key, such as homicide or aggravated assault. The stage is set with a seasoned defense attorney challenging a ballistics expert from a state police lab. The charges, though not explicitly stated, hinge on whether a specific firearm can be conclusively linked to
Those are all designed with certain specifications, right?
Correct.
Okay. So the statement in these reports about the firing pin outline design is not a statement about the manufacturing standard of the shell casing, right?
No.
Here, the defense attorney is smartly laying groundwork. He's making the expert distinguish between a shell casing's inherent manufactured design and the unique marks left by a specific firing pin. This is crucial because while manufacturing can create class characteristics, the prosecution's case often hinges on individual characteristics. The attorney is subtly isolating the specific evidence being relied upon, setting the stage to challenge its uniqueness.
It's about the outline that gets left by the firing pin of the weapon.
Correct.
Okay. So that firing pin of the weapon that we saw, right, can leave different sized markings on the same ammunition.
No.
This is a pivotal moment for the defense. The expert initially tries to resist, but the attorney is pressing on a known scientific reality. Even the same weapon, fired multiple times, can produce slightly different impressions. This challenges the notion of absolute unchanging uniqueness. Under the Daubert standard, which governs the admissibility of expert testimony in federal courts and many state courts, a method's known or potential error rate is a key factor. By getting the expert to concede variability, even if initially reluctant, the defense introduces doubt about the precision of the match.
So that, again, we'll just go over the firing pin, the tip of the firing pin, right? It's a circular firing pin. When you pull that trigger, the firing pin is hitting that primer. It's detonating that primer. That's what fires that cartridge case.
Sure.
So that firing pin, once it hits that primer, it makes a crater from that pin hitting it. All that is doing there for Nibin is measuring the crater, so to say. From this point, from the 12 o'clock position to the 6 o'clock position,
Right.
it's just taking that measurement of the crater and the firing pin on that primer.
Right. And then but the measurements it takes from shot to shot using the same weapon and still using nickel primer brass case shell casings left different size impressions from the firing pin.
It could.
Okay, so those are different marks in terms of their size.
Right, but it's not actually physically measuring the firing pin. It's measuring the crater that it hits.
I understand.
Right, the crater that it's causing.
Right, it's measuring the impression on the shell casing.
Yes, the impression on the shell casing.
But the impression on the shell casing is the thing that you use to determine if two things are like or if two things are unlike, right?
No, it's not. I'm not looking at the size of the crater of the impression. I'm looking at the tool marks inside that impression.
I understand what you're saying, but what I'm saying is, do you agree that the same tool, right, fired at relatively the same time?
The expert is attempting to pivot, asserting that they're looking at the tool marks within the impression, not just its overall size. This is a common strategy by ballistics experts to emphasize the microscopic striations and imperfections on the firing pin itself, which are considered unique. However, the defense attorney skillfully keeps bringing it back to the size of the overall impression, knowing that visible variations in size are easier for a jury to understand, as an indicator of potential inconsistency, rather than the more abstract concept of tool marks invisible to the naked eye. This targets the expert's confidence in the perceived infallibility of their methods.
Using ammunition of the same composite can create different sized impressions.
Difference, I get it. I assume it can.
Okay.
But again, you're not talking about the tool marks inside the firing pin impression. The tool marks on the imperfection on the tip of the firing pin. You're talking about the firing pin impression, the crater that it's leaving.
Yes.
On the primer.
Yes, that's right. I am. I'm just trying to make sure that I understand that the same tool fired at the same time with the same ammunition can leave different sized markings.
The crater of the firing pin? Yes.
It's an impression, is it not?
Yes, I'm agreeing with you.
It's a tool mark impression, right?
Correct.
And it's a tool mark impression that can create different sized impressions even when fired at the same time using the same ammunition.
Again, I don't take those measurements.
I'm not saying you do.
Right.
I'm just saying that this is a thing that happens.
Can it vary by thousandths of an inch? Yes.
Okay.
And there it is, a direct yes from the expert that the impressions can vary by thousandths of an inch. This is a significant concession. When a jury hears that variations, even microscopic ones, can occur, it erodes the idea of a perfect immutable fingerprint that ballistic evidence is often portrayed as. The defense has successfully highlighted a measurable limitation in the very evidence the prosecution relies on, planting a seed of reasonable doubt regarding the absolute certainty of a match.
Well, your microscope, what's its maximum magnification?
It could go up to over 100 times magnification.
Right.
But we're not talking about the same thing right now.
We're not, but when we're talking about 1/100th of an inch.
At this point, I have to object. This has been asked.
Yeah, he's asked and answered this many different ways, many different times.
The prosecutor here objects on the grounds of asked and answered, a common objection under rules of evidence. Typically, Rule 611A of the Federal Rules of Evidence are state equivalents. The judge agrees that the core question has been addressed, and the defense attorney is becoming repetitive. While the defense did get a key concession about variability, continuing to harp on it risks annoying the judge and potentially the jury. The judge's intervention shows he feels that the point has been made and reiterated sufficiently.
So, you're talking about two different things. If you want to try to specifically ask something, but what you have asked him right now, you have asked him several different ways, and he has answered it the way he's answered it. I'll just leave it that way.
So, you requested the ammunition, the Fiocchi ammunition, right?
I'm not sure if I requested it or if the prosecutor's office had that ammunition.
Now the attorney shifts gears entirely, moving to a critical aspect of forensic evidence, chain of custody, and the reliability of test materials. The expert's uncertainty about who requested the specific Fiocchi ammunition is a red flag. In any criminal proceeding, the provenance of evidence and test materials is paramount. If the expert can't confidently state the source or handling of the test ammunition, it could undermine the validity of the comparison test performed. This could violate principles of due process and the right to present a full defense, as it affects the reliability of evidence against the defendant.
And let me know. So I don't recall, sir.
Okay. I think you said yesterday that you were doing these test fires and the ammunition you had wasn't marking as well, right?
Yes.
So you were the one that came to that conclusion, right?
Yes.
Like maybe I don't have the right ammunition, right?
Correct.
Okay. And then you look for it at the state police lab, right?
Yes.
Because you want to use state police ammunition if you can, right?
Both. So we use our ammunition, but it's very important to use like ammunition. Yes, sir.
Right, but one of the things you said yesterday was that you don't really like taking ammunition from outside sources.
Correct.
Because you don't know where it's been.
Sure.
And you don't know if it could be damaged or something like that. So it's better to use the ammunition that you have at the armory if you can, right?
Yes, ideally, yes, sir.
The defense is now expertly creating a contradiction. He's getting the expert to admit to the ideal protocol, using internal, secure, and known ammunition from their own armory. This establishes a baseline for what best practice looks like. The attorney is setting a trap, knowing he's about to reveal that these best practices were not followed in this specific case. This line of questioning directly challenges the expert's credibility and the care taken in their investigation, which is a common defense tactic to raise reasonable doubt.
Okay. And typically, you said you don't like accepting outside ammunition, right?
Yes, sir.
Unless there was a reason for you to believe that it was reliable and useful, right?
Correct.
Okay. This property receipt that you saw yesterday, S351, it says that the ammunition was requested by you for further testing.
Yes, sir.
Okay. Does that sound accurate?
If that's what's in my notes, yes, that's accurate then.
Boom! The trap is sprung. The defense attorney confronts the expert with a property receipt, S351, explicitly showing that the expert himself requested the outside Fiachi ammunition, despite his stated preference for using internal armory stock. This isn't just about a procedural lapse. It's a direct hit on the expert's honesty, or at least their recollection. This directly challenges the expert's credibility, a key factor for a jury weighing their testimony. If an expert's testimony seems inconsistent or unreliable on one point, it can cast a shadow over their entire testimony, especially under rules like Federal Rule of Evidence 608, which allows for attacks on a witness's character for truthfulness.
Okay. How did you know that the prosecutor's office had that ammunition?
I don't know, sir.
You don't know. Because
I could have asked it, could have requested it from there, because again, it's best to use like ammunition.
But, I mean, in your typical shooting, there's not going to be a box of ammunition lying around at the crime scene, right?
I don't know, sir.
Well, is it typical in your casework that you receive a box of ammunition?
No, sir.
Okay. Of ammunition lying around at the crime scene, right?
I don't know, sir.
Well, is it typical in your casework that you receive a box of ammunition?
No, sir.
Okay.
To wrap up this line of attack, the attorney secures a final admission. Receiving a box of ammunition from a crime scene is not typical. This reinforces the unusual nature of the Fiachi ammunition in this case. The combined effect of these questions is to suggest that the ammunition used for testing was not handled according to best practices, potentially compromising the integrity of the ballistic comparison. This is a powerful closing argument for the defense, implying that the test results might be unreliable because the underlying materials were suspect. While specific details of the exact trial depicted in this transcript, including the defendant's name or the ultimate verdict, are not available from the provided text or readily identifiable through general search queries related to the technical ballistics discussion, this cross-examination illustrates a critical legal battleground. Cases relying heavily on ballistics evidence often face challenges regarding the uniqueness and reproducibility of tool marks, as well as the rigorous adherence to chain of custody for all evidence and test materials. Defense attorneys frequently employ these tactics to highlight the limitations of forensic science and ensure that the jury critically evaluates expert testimony. The outcome in such trials often hinges on how effectively the defense can sow seeds of doubt about the certainty of scientific conclusions, potentially leading to an acquittal or a hung jury, or at least a negotiation for a lesser charge. The meticulous nature of this cross-examination demonstrates the defense's commitment to holding scientific evidence to the highest standards, which is fundamental to a fair trial.